me start with the conundrum or paradox that makes this paper and John's other work on the Eighth Amendment interesting, which is how can the same punishment for the same conduct be cruel and unusual when imposed by one tribunal rather than another? If you look at the handout, you'll see that repugnant Star Chamber punishments were inflicted by the common law, as expounded by Blackston in item 2, where he talks about slitting of noses, lashes, pillory, and so on. And after Mason's 1776 Virginia Declaration, which is item 7, these same penalties were proposed in item 8 by Jefferson, Wythe, and Pendleton in the Virginia Bill to Proportion, proposed in 1779, and rejected in 1785. That's item 9. Item 9 is the first Congress's Act for the punishment of certain crimes, adopted after sending the Bill of Rights to the states for ratification, and it includes specifications for whipping of 39 stripes, standing in the pillory, and so on. Indeed, every punishment in the Star Chamber playbook can be found in the common law, in the proposed Jefferson Penal Code, or in the first Federal Criminal Act, with, so far as I know, the sole exception of the horseback ride face to tail, as the Star Chamber judges put it. Yet it was clear that the cruel and unusual formula was meant to prohibit Star Chamber punishments. The Habeas Corpus Act is item 3, abolishing the Star Chamber, citing violations of Magna Carta, the 6 confirming acts, and the creation of crimes and punishments unknown to law. The English Bill of Rights, item 5, condemns cruel and illegal punishment before prohibiting cruel and unusual ones. The immediate target of these phrases, as John points out, was the perpetual whipping and pillaring of Titus Oates. Blackston in item 6 tells us that the Bill of Rights on this point was declaratory and inspired by unprecedented actions in King's Bench, which can only refer to the Oates affair because the bloody assizes were on Oyer and Terminer Commission in the West Country, and the Oates trials themselves were at the Old Bailey on a jail delivery assizes commission. The only thing that could possibly have happened at Westminster and King's Bench was the Oates trial itself. So Blackston himself, in treating of perjury, says that when there's a foreseeable death of an innocent person, the perjurer, read Oates, would be guilty of murder and hang. So look closely at item 4. This is Jeffrey's nasty speech before, following Star Chamber protocol, he turns over pronouncement of the dreadful sentence to his junior colleague. Jeffrey says that since the act abolishing Star Chamber was premised on that tribunal's redundance with the common law, it followed that the King's Bench could do anything Star Chamber had done. For sheer brass, I can think of no rival but Admiral Danitz's claim to head of state immunity, as he was then the legal successor to Adolf Hitler. Legal in a sense to which we will return. Now, John's answer is to say that the founders meant to forbid the return of penalties they inflicted themselves, provided those penalties became archaic and excessive. It is not clear how much work is really done by the cruel term, since defendants would only challenge the return of archaic penalties if they were worse than the ones they would otherwise face. At any rate, this solves the problem by saying Star Chamber punishments were okay in 1791, but would eventually become not okay. There is little direct support for this and considerable opposing evidence. To begin with, I think John's account means that Parliament in 1690, Virginia in 1777, or Congress in 1792 could have reinstituted Star Chamber sentencing practices by giving common law courts the lawless discretion claimed by Jeffreys. That seems implausible. Moreover, it is highly probable that the Virginia bill, item 8, flunked John's test re adultery, and the congressional death penalty without clergy for forgery in item 9 probably flunked his test as well. Several explanations have been offered as to why the proposal by Jefferson and his committee did not pass. None of them suggest that it was rejected because of conflict with the Declaration of Rights. The James case on which John relies includes 3 opinions on a court of 5 judges, Rowan saying the joint fine was contra common law, but if authorized by statute would probably be unconstitutional. Pendleton says the joint fine, not being contrary to common law, ought to be upheld, so that's 1 judge of 5 total and 3 on record in a case about fines supporting John's account of cruel and unusual. The subsequent Wyatt case John mentions construes a misdrafted statute facially authorizing 6 months in jail, plus 39 stripes imposed as often as the judge decrees, a penalty that would be torturously fatal if done, say, 3 times a day, to be a commitment to the judge's sound discretion, not a lawless grant of power open to sadistic, discriminatory, or merely random exercise. The archaic plus harsher formula is vague as to what counts as archaic. Solitary is distinct from prison. For prison murderers or for car thieves, for juveniles or adults, legislatures thinking of legalizing marijuana or abolishing mandatory minimums might have to think twice about whether they're throwing the switch on a one-way racket. What about moving the other direction? Is it unconstitutional to move, say, for domestic violence from misdemeanor to felony classification, which carries with it life-crippling collateral consequences? His analysis of accidental punishments is more radical than it seems. I strongly suspect that the odds of first-time prisoners being raped is considerably higher than the odds of a botched execution. And if that's right, then it might make any commitment to our current correctional system cruel and unusual in his sense. What alternative? Try this. Suppose that cruel and unusual means harsher than law allows. Suppose further that executive fiat, the decree of a prerogative so-called court, does not count as law. Suppose still further that statutes cannot solely by pedigree make the exercise of lawless discretion, quote unquote legal, at least in the sense of the tradition inspired by the English Bill of Rights. On that account, what Star Chamber did was cruel and unusual because it was unbounded by law, and what Jeffreys threatened was to clone that dormant virus and infect the common law with it. So how then can the same punishments be proper when prescribed by Blackston's common law, by Jefferson's bill, or by the First Congress? Blackston in item 2 denies any judicial discretion, which is a joke, but a joke with a grain of truth in it. Once all the funhouse mirrors and trapdoors of common law procedure led improbably to a guilty verdict, and if there was no glitch in the indictment on a motion for arrest and no room for clergy, the judge really did have no discretion, and only pardon could save the pickpocket from the noose. Now look at the American codes. Item 8, Jefferson's bill, allows for almost no discretion. Stripes and fines are discretionary in a few cases, but only the discretion of the jury, not the court. Prison terms have a mandatory minimum and a mandatory maximum, which are one and the same. The bill revoked not just the benefit of clergy, but the pardon power as well. Under the Federal Act, item 9, death where prescribed was mandatory, the benefit of clergy, albeit not pardon, being eliminated. Prison terms were discretionary, but the Act does not say whether judges or jury was to exercise that discretion. There was no mandatory prison terms, and the widest scope of discretion regarding prison is 0 to 7. The most common is 0 to 3. To people who work in modern courthouses, that band of discretion is shockingly narrow. I nod to Laurie Klaus here, who I think was on the right track in viewing the constitutional principle more as anti-discrimination than as anti-cruelty. But the fundamental objection was not to bigotry. 2 minutes and 2 paragraphs. I'm there. The fundamental objection was not to bigotry or sadism, but to the lawless discretion that empowered base motives or even coin flips. Duly constrained by reasoned statutes and the various constitutional fair trial requirements, death, whipping, branding, or mutilation might be cruel, as all punishment is, and intentionally cruel, as all punishment is. But none would necessarily violate, quote, cruel and unusual, quote, as a term of art forbidding lawless discretion to inflict great pain. No statute conferring such lawless discretion would count as law, and without lawless discretion, legislative enthusiasm for harsh penalties of any type would be appropriately subdued. Such, at least, is my view of the cathedral, or, if you like, the penitentiary. If substantiated, the takeaway would be that there is more historical ground than you might suppose for the court's guided discretion jurisprudence, and there is less support than you might think for its death is different dogma. That, in turn, might lead us to ponder the embarrassingly close parallels between the Star Chamber and the U.S. Attorney's Office.
Thank you very much, Don. Would you like to respond, John?
Briefly, because there was a lot in there, and it's probably more than I can handle all at once. But let me one foundational point, though, is that as far as I know, the Star Chamber has nothing to do with the adoption of the Cruel and Unusual Punishments Clause either in England or America. You may notice the date of the act abolishing the Star Chamber, 1640. The English version of the Cruel and Unusual Punishments Clause was adopted in 1690, 50 years later. And second point about the Star Chamber, like other sort of civil courts in England, the Star Chamber was regularly criticized for flouting all sorts of common law limits on criminal procedure. And it's not true that all the punishments that were given in these civil courts were permissible at common law. For example, in the 15th century, Jonathan Fortescue criticized civil law practices of using the rack as a form of punishment, saying that torture as a mode of punishment was absolutely illegal under the common law. So really, when we think about the Star Chamber, the significance of that is that in England there was simultaneously sort of a civil law criminal jurisdiction and a common law jurisdiction. The civil law jurisdiction did not sort of respect many of the limits, procedural and substantive, on punishment that were required by the common law. Common lawyers regularly complained that this was an illegal exercise of power by the king. And if you look in America in the 18th century too, for example, when there was a move during the Revolutionary era to try American colonists in the Admiralty Court, right? The argument was, well, this is like Star Chamber because there's no jury, right? So the Star Chamber was certainly something people thought of as evil, and evil in large part because it was contrary to common law limitations in all sorts of ways. But there's no direct line between the punishments inflicted at Star Chamber and those that are condemned by the Cruel and Unusual Punishments Clause. I'll leave it at that, and I can answer other questions as they come up.